and read by an automated voice. The Justice Department said on Monday that Trump officials would immediately begin the process of expelling Kilmar Armando Abrego Garcia from the country again if he is released from custody next week, on charges filed after his wrongful deportation to El Salvador in March. That plan, laid out by a Justice Department lawyer at a hearing in federal district court in Maryland, directly contradicted a statement by the White House last month describing the possibility that the administration might re-deport Mr. Abrego Garcia as, quote, fake news. At the hearing, Judge Paula Shinas, who is overseeing the original civil case emerging from the wrongful deportation, expressed frustration at the government's shifting statements about its plans to handle Mr. Abrego Garcia. The statements in court by the Justice Department lawyer Jonathan Gein further muddied an already unclear picture of Mr. Abrego Garcia's future after the administration abruptly returned him to the United States last month to face criminal charges. At one point, Judge Shinas compared getting certain answers out of the government to nailing Jell-O to a wall. At another point, she described the, quote, complete chaos that had arisen from Mr. Abrego Garcia's being, quote, between his civil case in Maryland and his criminal case in federal district court in Nashville. Mr. Abrego Garcia is in custody in Nashville, where he has been indicted on charges of taking part in a years-long conspiracy to smuggle undocumented immigrants across the United States. Even though a federal magistrate judge has said he can go free because he was not a flight risk or a danger to the community, his lawyers asked that he remain locked up for the moment, fearing that the administration might seek to deport him again. There has been persistent confusion about what might happen to Mr. Abrego Garcia almost from the moment he was brought back from his erroneous expulsion to El Salvador. Much of the confusion has stemmed from ambiguous and contradictory statements from the Trump administration, and from what appears to be dueling views from the Justice Department and the Department of Homeland Security about how to handle the case. When Attorney General Pam Bondi announced on June 6th that Mr. Abrego Garcia had been returned to the United States to face indictment, she insisted that he would be re-deported only after his criminal case was over. Upon completion of his sentence, Ms. Bondi said, we anticipate he will be returned to his home country of El Salvador. But at a separate hearing in late June, Mr. Gein told Judge Shinas that the administration planned to expel Mr. Abrego Garcia again, this time not to El Salvador, but to an unnamed third country. In another puzzling move, top Justice Department officials have repeatedly insisted that they intend to try Mr. Abrego Garcia on the immigrant smuggling charges before seeking to expel him again. But the prosecutors handling his criminal case have offered a more ambiguous assessment. They recently told the judge in Tennessee that while they plan to press forward with the criminal prosecution, officials at the Department of Homeland Security, which oversees matters of immigration, must follow their own process in dealing with Mr. Abrego Garcia's, quote, immigration proceedings and potential deportation. The hearing in Maryland on Monday was convened so that Judge Shinas could consider, among other things, an emergency request by Mr. Abrego Garcia's lawyers to bring him back to Maryland and to prevent him from being sent out of the country again until further notice. Judge Shinas drilled down on the government's plans, asking Mr. Gein if the administration intended to wait until the criminal case was over to begin new deportation proceedings. When Mr. Gein told the judge that was not the administration's plan, she asked him again, "So you're not waiting until after the criminal trial?" "That's correct," Mr. Gein responded. While Judge Shinas did not rule on the emergency request, she ordered the Justice Department to produce a witness from the Department of Homeland Security on Thursday to testify about its plans for Mr. Abrego Garcia. The judge overseeing the criminal case, Waverly D. Crenshaw Jr., is set to hold his own hearing in Tennessee on July 16th to determine whether Mr. Abrego Garcia should be freed and handed over to DHS officials. From the moment that Mr. Abrego Garcia was returned to U.S. soil, the Justice Department has maintained that his civil case was over. Department lawyers have argued that by bringing him back, they have complied with orders from Judge Zenas and from the Supreme Court to facilitate his release from Salvadoran custody. But Mr. Abrego Garcia's lawyers have rejected that view, saying that the civil case remains alive. They have argued that even though the administration has obeyed part of the court orders by bringing their client back to the United States, they need to return him to Maryland to fully comply with the instructions from the Supreme Court. Last week, Mr. Abrego Garcia's lawyers made another request to Judge Zenas, asking her to permit them to revise their initial complaint with allegations that their client was tortured while in Salvadoran custody. In court papers, the lawyers described how Mr. Abrego Garcia was beaten, deprived of sleep, and kept in the dark during his early weeks in El Salvador, when he was held at the mega prison known as CICOT. Mr. Guine said on Monday that the Justice Department planned to oppose the request to revise the complaint, saying that the torture allegations had not been brought in, quote, good faith.